You are AEL Garcia.
Sir.
Mr. Garcia, so
He's charged with, I've never seen this before, Judge, but he's charged with violating a bond condition.
What happens when someone violates their bond conditions not once, not twice, but 3 times? Today's courtroom showdown features a defendant with a loaded gun, a woman who ignored every court order thrown at her, and a man passed out drunk behind the wheel with 2 open containers. These aren't just legal slip-ups. These are people playing Russian roulette with their freedom. The judge, he's had it. And when you see what he does to these repeat offenders, you'll understand why violating bond conditions might be the worst decision you can make in the legal system. Let's dive into this judicial smackdown.
yeah, I've certainly seen it. It's
not a protective order, it's a bond condition.
Right, because they can't make the protective order case because it's been more than 61 days, right?
Nothing to do with the protective order, Judge.
So, yeah, right, I get it.
It was a different situation completely. Had nothing to do with family violence.
We'll get there. So you're charged with violation of a bond condition / protective order. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. If you cannot afford a lawyer be appointed to represent you. So before we start, was he in a PTI? Is that why this case is 1,000 days old?
Yes, sir. He just has a few BIP classes left to finish the PTI.
Okay. Okay, go for it.
Judge. The officer was dispatched to a business in Harris County, Texas, in response to a disturbance. Upon arrival, the officer observed the defendant grab another male aggressively, and the officer conducted a search on the defendant's person and found a loaded gun in the front pocket. The defendant is currently on bond for an assault family violence and has bond conditions in place prohibiting from possessing a firearm.
Yeah, all right. Mr. Gracia, I'm going to find that there's probable cause to go forward on the bond conditions. State, what's your position as far as he's in a PTI? He's now picked up a new case. Mr. Gracia, I want you to know that we take these bond conditions extremely serious.
Sir.
You don't, though. This is not your first VPO. This is not your first violation of bond condition. You don't get it. No means no. Doesn't mean maybe. Doesn't mean I'm going to a high crime area. No means no. And now there are consequences.
Hold up. Did the judge just say no means no? This is where things get real. See, bond conditions aren't suggestions. They're legally binding orders. When you're on bond for assault family violence and you're caught with a loaded gun, you just escalated from bad decision to potential disaster. The judge isn't just being harsh here. He's seen this pattern before. Defendants who violate bond conditions, especially weapons restrictions, are statistically more likely to commit violent crimes. And notice how the defense attorney is about to try to explain the situation. Watch how the judge absolutely destroys this excuse. This is about to get uncomfortable.
Stephen.
Judge, can I tell you a little bit about the case?
Sure.
Just to explain to you what happened. He was at his business. He owns a trucking company. He hired somebody who he said he took a chance on him because he has a sketchy record, convicted felon. It didn't work out within a couple of days. So he ended up firing the individual. The individual refused to leave the premises or refused to accept it. So he started threatening him. He went inside. The individual started trying to damage the trucks. So at that point, he was fearful. He went and retrieved a firearm that he knew was hidden in the vehicle. I'm sorry, in there. I understand, Judge.
It's about the worst thing that you can do. Imagine if you use the firearm. Who gets charged with murder? Mr. Gracia? Who has now dug themselves into a potential 50-year hole? We have a case like that today where a meager argument, someone who's charged with assault is now charged with murder because of a silly ass, stupid ass argument. Now, dude is sitting in custody with a $250,000.
The judge just dropped a truth bomb. He's not talking hypotheticals. He literally has a murder case today from someone who was on bond and used a firearm. This is a reality check every defendant needs to hear. When you're already facing assault charges and you pull a gun, even in self-defense, you become the aggressor In the eyes of the law, the defense attorneys try and play he was protecting his business card. But here's the legal reality. When you're on bond with weapon restrictions, you lose certain self-defense privileges. You know what Mr. Garcia should have done? Called 911. It's that simple. But let's see if this defense attorney can pull off a miracle, because right now, his client is looking at serious jail time.
And he's been punished at this point, Judge. He's been punished for violating the bond by getting an entire new case on that. So as far as him going into custody for violating the bond condition, I would hope that you would take that into consideration, the fact that he has gotten punished on the bond violation already, and the fact that he's already had to hire a new attorney for two cases at this point, and it's probably going to affect the other case. So I would hope that you would continue supervision on that, just taking that into consideration.
I truly appreciate your position, but you have an assault from 2019 of a family member. The following year, you pick up a violation of a protective order or bond condition. Now you have another assault that they were even, what the hell you're looking over there? Was it Jesus over there? You already have an assault of a family member that was dismissed as it is. You were lucky enough to even have this kind of an agreement where they're willing to dismiss a second assault of a family member. And now you pick up another violation of a bond condition. Eric, he doesn't get it.
I understand, Judge.
You don't get it. And now I have to show you we mean business. I think that you're in utter and complete danger to public safety. And I will do everything in my power to protect my public in every single way. Because the last thing I want is you to pick up a murder case like we have here this morning. Someone else goes with you.
Judge, one more
Jesus
thing.
over there. The sass from this judge is unmatched. But here's what's really happening. The judge just laid out this defendant's entire criminal pattern. 2019 assault, 2020 violation, and now this. This isn't bad luck. It's a pattern of behavior. When judges see repeat offenders who keep escalating, they have a legal and moral obligation to protect the community. Notice how the judge says, I think you're in utter and complete danger to public safety. That's going on the record. That statement alone can influence future bail hearings, sentencing, and parole decisions. This defendant just got labeled as a public threat by a sitting judge. The ripple effects of this moment will follow him through the entire legal system.
Judge, one more thing. There's a bond condition on there that he's not allowed to return to that address. That address is his business. It's his place of business. The other person has no right to that address. He hasn't worked for the last week and a half because there's a bond condition, I'm assuming from the magistrate, that doesn't allow him to go back to that business.
Show me proof.
I'd like to be
Show
able
me
to take
proof. And, the proper, and you need to advise, the proper way to do things is you call the cops.
that. Get a judge.
Really. I mean, that's, if you own the business, you show it. I mean, how easy would it have been to just call police?
I mean, he has a right to defend his property and
Not while the case is open. He does, but not in that manner.
It's one of those things where things happen quick and you have to make a decision. And when we're talking about trucks that are worth hundreds of thousands of dollars and things like that.
911, man. Really?
How long do they take to get there, Judge? So
Okay. They will still take his ass to jail and then, try to get restitution or whatnot. But
So as far as the bond goes, can you set him a bond today?
Of course.
And Judge, we've contacted Conrad because it's his case, but I just want to confirm that bond has been revoked for his prior case. Is that correct?
yeah,
Okay.
yeah. On the assault, I'm revoking it.
Yes, Judge.
Looks like they set the bond at 20,000 on the new case.
Yes, Judge.
I'm gonna mirror it.
Because he's already posted that bond. He's already hired me. He hired me on the other case as well. There's a motion to sub in your queue that I need you to sign as well.
I'll sign it for you.
I'd ask that you set that new bond at $500. It's tough for the family, Judge. I mean, at this point, he hasn't worked in 2 weeks. He's trying to get back on his feet. He did everything properly. He didn't go back to the location because of the bond condition.
I'm not doing $500. I mean, I was thinking that was going to mirror the same one. I was to put it at
And that would be the
20,000.
state's position to mirror.
So he understands that we mean business. If he's unable to bond out, I'm always willing to talk after a couple days, but I want him to understand that we take it absolutely serious. And when you go over there with a gun with the intent to do some serious damage, hell no. No way. No. And I think that making it 20,000, what the other one is, hopefully it'll get his attention. But like I said, look,
10,000?
like I'm not out for blood, Eric, so if he's unable to, after some time, come back, and I'm not talking weeks, but a couple days, so he realizes that we mean business.
So we're talking about 2 weeks minimum. So would you consider giving 10,000?
Well, remember, I Zoom, so you can be in Abu Dhabi. I'm still here.
His mom's present, so let me talk to her.
Yeah, for sure. Okay.
When we were here last time, he ordered her to have the interlock installed on her vehicle. She is not driving the vehicle. It's not drivable. We just need to switch her to a portable.
Oh, no.
And a no drive.
She has nothing. And it doesn't matter. We ordered you to have an interlock in a car. You haven't done anything, and you're without any kind of devices whatsoever, right?
That was totaled, and it's at my house right now. But I don't have I'm in a rental car that I'm not driving, so I don't have a car to put it in.
So you have no device.
That's correct.
You're not being monitored.
That's correct.
This is not a good thing, Ms. Lynch, because I ordered you to have a device. And from what I understand here, you never even went and got it.
Because she doesn't have a vehicle to put it on.
But you come back and you say, hey, judge, I don't have a vehicle. I need to do something else. You just don't, out of sight, out of mind. That's not the way things work.
And here comes defendant number 2. Miss Lynch just admitted she has a no interlock device, and no monitoring, and apparently thought out of sight, out of mind, was a valid legal strategy. Let me break this down. An interlock device is a breathalyzer for your car that prevents it from starting if you've been drinking. Courts order these for DUI offenders. But here's the kicker. She's claiming she doesn't have a car to install it in, yet she's somehow here at court. The judge isn't buying it, and neither should you. When a court orders you to install an interlock, you either install it or immediately petition the court for alternatives. You don't just ignore it and hope nobody notices. This woman is about to learn that courts have very long memories.
Judge, for that violation as well, we instructed her in court and sent a message for her to report to 49 following court to get further instruction over everything so that we could figure out things from there, and she never reported.
Stephen, Ms. Lynch, you haven't done anything. They've literally bent over backwards to help you and do stuff, and you haven't done anything.
I wanted to come in today.
The only reason you're here today is because I ordered you here
Yes,
today.
sir. Yes, sir.
She goes with you.
Yes, sir.
Emailed, texted, call, nothing,
I understand. Would you consider setting her a new bond or
Of
default?
course, 5,001. And then, if she's unable to, then what's today, Friday, Monday, then we can talk. Okay?
That makes you start.
Yes, ma'am. Thanks. Okay, you ready? Hi, good morning. Give me good news.
Joshua Jones.
Oh,
So he's here for a PTI violation. He has picked up new cases.
come up, Joshua Jones.
I was just gonna ask you if we could withdraw. He's nearly a year past due. He owes us over $2,000. We don't want to get on the new case. Allow him some time to hire an attorney that can handle.
I'm okay with it. Yeah.
Okay.
Yes, that's fine. And so I will have to appoint him someone, Mr. Jones, let me express my disappointment with you. You were was he in the PTI program?
To my knowledge, he had a
You
previous
were in the
attorney.
intervention program for DWI, and now you've picked up another DWI. You now face another 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed if you cannot afford one.
Yes, Judge. On November 17th, 2024, an officer was dispatched to a person down call at the 15,000 block Intercontinental Road, and upon contact, the officer made contact with a witness who advised he observed the defendant to be asleep in the driver's seat of his motor vehicle. Despite the witness's attempts to wake the defendant did not wake up, and the witness turned the defendant's vehicle off in order to maintain his safety. The officer observed the defendant asleep in the driver's seat of the motor vehicle and also had unsuccessful attempts at waking up the defendant. When the defendant finally woke up after the officer made physical contact with him, the officer observed an unholstered black pistol in the driver's door and 2 half-consumed alcoholic beverages inside the truck.
Drinking while driving?
Yes, Judge. And standard field sobriety tests were refused. DIC was read and the defendant consented to breath and blood. Blood was drawn due to the defendant being unable to give 2 breath samples.
Wait. This man was so drunk he couldn't wake up when strangers were shaking him, had an unholstered pistol in his door panel, 2 open containers, and was in a pre-trial intervention program for a previous DWI. This is a legal equivalent of playing with fire while covered in gasoline. PTI programs are second chances. They're diversionary programs that let you avoid conviction if you complete certain requirements. But picking up a new DWI while in PTI, that's not just violating the program. That's spitting in the face of the court's mercy. And the gun? In Texas, carrying while intoxicated is a Class A misdemeanor. This guy just stacked charges like he's collecting Pokemon cards. The judge is about to go nuclear.
Mr. Jones, I'm going to find that there's probable cause to go forward with the case. I am now finding that you're a complete and utter danger to the public, and I am taking away your privilege to drive. You will be signing an affidavit with me today promising me you're not going to drive, and I don't give a rat's behind what your excuse is if I find that you drive. I will have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? Because of the nature of the case, because you have an open container, 2 open containers with the DWI, I'm now revoking both of your bonds and I'm going to set them at $25,000 each. Do you understand? He goes with you. I'll sign your motion to withdraw.
She's just staring
Come on around.
at the front. It was here on the case.
Have you guys removed him from the case?
Yes, Judge. He's been removed from the program.
Hi, Mr. D.
Good morning, Your Honor. Good afternoon, Your Honor.
Yeah.
Judge, I am here on Mr. Alejandro Guardado. Looks like it's an MRP judge. I've been informed that
Come up, Mr. Guardado.
my client had tested positive for cocaine, I believe. I think this is his second or third time testing positive. We want to know what direction you.
Hey, this isn't the club, man. You. So you trying to talk to her. This isn't the club, man.
Yes, sir. No, sir. Yes, yes, sir. Yes, sir.
Get your brother. Mr. Guardado, you were placed on probation for a very serious case and you've had issue after issue. The reason I brought you here was try to ensure that we could get you on the right path, but you're continuing to use, and you just today tested positive for cocaine again. And I'm at a remiss that they didn't even inform us in February when the first time you tested positive for cocaine. So now I'm issuing a motion to revoke your probation and I'm issuing a warrant for your arrest. I've appointed you a lawyer so we can figure something out, but you can't continue to use cocaine while you're on probation and expect good things. Do you understand?
Yes, sir.
Okay. So what I would suggest at this time is we probably get a TRAS to see how we go forward, because I just don't know.
Yes,
You're
sir.
using, and that's not something you're supposed to be using, you know? It goes with you.
Yes, thank you.
All right.
How much you said in the bond, Judge?
What's it at now? 5,001.
Let's break down what just happened in this courtroom massacre. We witness for defendants learn that violating court orders isn't a game. Mr. Garcia, his bond got revoked and reset at $20,000 for carrying a loaded gun while on bond for assault. Miss Lynch ignored her interlock requirements and got hit with a $50,000 bond. Joshua Jones caught two $25,000 bonds for his second DWI with open containers and a gun. And Mr. Galdo, multiple positive cocaine tests while on probation, earned him a motion to revoke and an arrest warrant. The common thread? They all thought court orders were suggestions, not requirements. This judge made it crystal clear. Bond conditions are non-negotiable. When you're given a second chance through PTI, probation, or bond, you either follow every rule or face the consequences. The legal system isn't playing games, and neither should defendants. If this courtroom drama shocked you, hit that like button, drop a comment about which case surprised you most, and subscribe for more jaw-dropping legal breakdowns. Remember, when a judge says no, it doesn't mean maybe, it means no.